Welcome, Lordships.
Ladyships, please after your seat. We are all grateful to you. It's a great honor for Friday Group.
Thank you.
On behalf of Friday Group, this is our small.
Thank you so much.
Please.
Yes.
Please sit down. Ruma, please come. Madam, Ruma will give this clip somewhere.
Yes.
That's it. Madam, so push
Wherever is most effective.
It will go without any this. Correct. Idhar karo. Click to, correct.
So we have
Yeah, please. Only 1-2 minutes.
Yes.
Friends, we are starting now. This is our 160th Friday group meeting. So, leadership is here. This is Nagarathna. We are very grateful to you, leaderships. Very unusual. Everyone. Narsimha is our friend. He is coming here. Different. Indu Malhotra is different. Lalit is coming. He is our colleague here. But here is always totally different. Everyone is appreciating here. It's a great. It's a image went very high Friday group. Honestly, believe it or not. So normally this is today's topic is Hindu women's right to property, road to empowerment.
Yes.
Normally we will go by one introduction, but today we are not taking because so many people are here. It will take this thing. So right now, and Ruma, kindly Ruma will say a few words about Madam C.V. Yeah, you take this one like that side. This mic that side. वो रहने दे उसको डिस्टर्ब मत।
Honorable Justice B.V. Nagarathna, born on 30th October 1962 at Bangalore. She have done BA Honours in History from G.Seshagiri College, Delhi University in 1984. Obtained her LLB degree in July 1987 from Campus Law Center, Delhi University. She has started her practice in law in 1987, initially in Keshvi and Company Advocates, and started independent practice in July 1994 till elevation as a judge of the High Court of Karnataka in 2008. Madam has practiced in a wide variety of areas such as administrative law, constitutional law, commercial law, family law, etc. Represented Karnataka State Legal Service Authority and High Court Legal Service Committee. She was also appointed as amicus curiae in certain cases. She has appointed as on 18th February 2008 as additional judge in Karnataka High Court and permanent judge on 17th February 2010. Some of the position held as judge of High Court of Karnataka as President Karnataka Judicial Academy, President Bangalore Mediation Center, Bangalore. Her contribution to the book Courts of India, released by the Supreme Court on the chapter on Courts of Karnataka, chairperson of committee in charge of bringing out Kannada translation of book Court of India, released in April 2021. She is elevated as Judge of the Supreme Court of India on 31st August 2021. Madam is going to be the first female Chief Justice on 24th September 2027. And she is going to retire on 29th October 2027. Thank you so much.
Thank you.
Now you can start your.
Yes. A very good afternoon to all of you. After a long Friday working day, which usually finishes by 1:30 or so, but we just rose from court and hearing advocates from morning till now, I think it's a pleasure now for me to address the advocates. Secondly, I always deem it a pleasure to share thoughts on questions of law or on subjects of law, because I think it's a part of what I call Acharya Rana. and that is our obligation to our teachers to share what we have learned from our teachers with others who are interested in the subject. And it is in that context I always used to enjoy my lectures in the Karnataka Judicial Academy. Just to give a brief background, from 1/3/2012 I was a governor there, and then of the academy, and started lecturing there, and eventually in 2020 January I became the president of the academy, and that made me a student, a teacher, a principal, an administrator of an institution, all rolled into one, because I had to envision things from the point of view of the judicial officers who were the trainees and students, from the point of view of the resource persons, from the point of view of the director, and from the point of view of the president of the academy. So that gave me a lot of exposure to what you call academic matters, though I had no opportunity to teach as such. And it is with that small background that I am now facing a huge audience here. So I hope I am acquitted at the end of the whole thing. So Mr. Sheshagiri Rao, administrator of the Friday Group, learned senior advocates and learned advocates, and ladies and gentlemen, at the outset I thank the Friday Group for giving me this unique opportunity to share my views on Hindu women's right to property, road to empowerment. As I said, it's not my views, I am not sitting on the dais, it is not that I am speaking as a judge here, but as a student of law, and I think just as all of you are students of law, so we are here assembled as students of law. Now when I think of empowerment, and that too as on the topic of empowerment of women, I must say that women's empowerment has many facets. According to me, it is first of all securing a woman's sense of self-worth. Secondly, a woman's right to determine the right of choice of action. Third, a woman's right to have access to opportunities in every field of activity and resources, including ownership of land and property. Fourth, a woman's right to have the power to control her life both within and outside the home, of course, subject to her duties to her family and as a citizen of the nation. Fifth, her ability to influence the direction of social change so as to create a more just social and economic order, both nationally and internationally. It is in this context of empowerment that I would say that empowerment of women would ultimately mean social, economic, political, psychological empowerment. One cannot be without the other. You cannot have only economic empowerment without social empowerment, and vice versa. It is not only imperative but also crucial for all-round development of society and the nation as a whole, that is, empowerment of women. The narrative on women's empowerment would be incomplete without referring to the aspect of her right to property, including economic power, in a broad sense of the term, which includes her right to livelihood and more gender equality patterns, wealth distribution, household bargaining power, right to livelihood and decision making. Studies by development economists suggest that securing property rights and inheritance rights are among the most effective means of achieving women's empowerment, particularly in developing countries. Recently we read, I think in the newspapers, as to how there is no GDP or value assessed with regard to the household work done by women. The contribution which a homemaker makes to the economy is not really accounted for at all. And I'm sure all the men here would agree that it is because of an efficient homemaker that all of you are successful in your respective careers. Studies by development economists suggest that securing property rights and inheritance rights are among the most effective means of achieving women's empowerment, particularly in developing countries. Therefore, laws and policies that seek to improve the position of women in matters of right to property and inheritance have been endorsed and advocated, in addition to those which seek to improve economic opportunities for women. Now, for this enlightened audience, I need not go into Article 14, Article 15, Article 15.3, Article 16 with regard to equality in employment, public employment, etc. But I would go straight away to the topic of the day, and in that context I would preface it by saying that in India, property rights of women have evolved out of a continuous struggle and debate between the status quo and the progressive forces. And in this context, I would like to restrict myself, owing to paucity of time, only with regard to Hindu women's right to property. Now, while tracing this journey up to the amended provision of Section 6 of the Hindu Succession Act, which has come into effect on 9th of September 2005, I must say that the position of women vis-a-vis their right to property is not only clothed with legislations from time to time, but also with regard to the judgments not only of the Supreme Court but of the other high courts also. When we talk of women's right to property, we always talk of Manu Smriti and what Manu said. He said, and I quote, that insofar as a woman is concerned, that her father protects her in childhood, her husband protects her in youth, and her sons protect her in old age. A woman is never fit for independence. Now you keep aside this women are not fit for independence. Let me digress a bit when it comes to father, husband and son. What is the position of women in India today? There have been cases filed by a girl child against a father under POCSO Act. There are cases filed by a wife against a husband in respect of dowry and cruelty. And there are cases of elderly women being filed against their children for getting back their property or maintenance because under some undue influence they had written it off. So when you think of this, what Manu said, it is a very ideal situation where a woman is looked after by her father, by her husband and by her sons. Alas, that is not the position. That is only in a very ideal kind of situation or society which is not there. Therefore, I said you split that quotation to the first part and the second part. A woman is never fit for independence. She never required any independence, I suppose, what Manu said, if all these things were taken care of by her father, by her husband and by her sons. In other words, if you interpret that positively, it means that it was not required for any woman to think of insecurity, either of her person or physically, mentally, economically, socially, psychologically or whatever else you may say, because these three categories of persons were always there to look after her. But that is only in an ideal society. Alas, it doesn't happen, as I gave the examples of what is happening, and therefore that ideal never exists. Women have historically not enjoyed unqualified rights in matters of property, inheritance or maintenance. Restriction on Hindu women's property rights have, however, undergone a change from time to time, from decade to decade. Initially, we all know that a woman's right to property was only with regard to her Stridhana, which was given to her at the time of marriage. And even there, Kautilya says that after the death of her husband, only if she is chaste and if her father-in-law permits, she has access to enjoy that Stridhana. Otherwise, she does not have. So it was only regarding what gifts were given to her during the time of her marriage, and if such a lady did not get married, she would not have even that Stridhana. But with the passage of time, the property rights of women have increased with centuries, I must say, not decades, because initially it was only with regard to the self-acquired property of the male that a female was entitled to a share, and thereafterwards in the co-pastory property or the joint family property also, that has now come about with regard to the amendment made to section 6 under the 9th of September amendment of 2005. Now for this audience, I need not explain what property is in the sense of Hindu joint family. We all know that it is co-pastory property and self-acquired property. Co-pastory property is again classified as ancestral property and joint family property, and joint family property is again classified as joint family property acquired with the aid of ancestral property and joint family property acquired without its aid but treated as joint family property or property of the entire family. Now if you think of the what you call the evolution of the rights of Hindu women vis-a-vis property, one cannot lose sight of the nature of Hindu society as it was historically speaking. We all know that joint family was the norm and nuclear family was only out of necessity. But today it is the reverse. Nuclear family has become the norm and a joint family is hardly there at all. It is because of this change in society that has actually led to the amendments being made by the Parliament from time to time, and prior to that, even during the times of when the British were, I won't say ruling or whatever they were doing here, at that time also the amendments were brought right from 1929 onwards. So a joint family under the Hindu society lives together not only in food and worship but also estate. There could be a joint family without any property. It is not that a Hindu joint family must possess, but what was important was that they lived together in food and estate. The jointness was not on account of property, but on account of there being that wholesome relationship between the members of the joint family. That is why I think Manu said in that ideal situation that a woman need not worry at all. There are her husband, her father, her husband, or if her husband died, then her other brothers-in-law, sisters-in-law, a child widow or a middle-aged widow or an aged widow never had to have any kind of insecurity. She would be involved in the joint family. She would not be sent out, unlike what we have now. If you see what is happening in Vrindavan, in not Vrindavan, in Mathura, and if you see in Varanasi, they're all sent out. That is why I had to write, if I may go personally a bit, under section 17 of the Domestic Violence Act, that a woman has a right to live in the shared household. Otherwise, think of this situation. A lady gets married, she is not working, she is a homemaker, and if she is thrown out of the house, where does she go? Therefore, her right to live in a shared household must be assured. That is also not exactly a property right, but a right which is necessary for the protection of women. Then we had slowly the codification of the classical Hindu law, which came initially in the context of Hindu Law of Inheritance Amendment Act of 1929 during the British times, when they started giving a share to a certain number of female members of the joint family in intestate succession, but only with regard to self-acquired property of a male Hindu who died intestate. That was recognized throughout India, but initially it was there insofar as Madras and Bombay regions are concerned, but the British brought about this law, Hindu Law of Inheritance Amendment Act 1929. Then came the Hindu Women's Right to Property Act 1937. That is a British enactment again, where the legislation recognized the widow's interest, and that was in lieu of partition. She could have this right to property only for her maintenance. It was called a widow's estate. After her death, it would revert to who are called the reversioners. There was no question of her having an absolute right over that property. But in Karnataka, where the Mysore rule was there, in Mysore state, we were more enlightened, I suppose, because we had the Mysore Hindu Law Women's Right Act 1933, where the same thing was there. She could seek partition, and the right of inheritance to a deceased property was recognized, though it was again a limited estate. And also the property in the form of Stridhana which she could alienate was conferred. Then after that, after we gained independence, then we had the 1956 Act in the form of the Hindu Succession Act. There are two major departures which are made in favor of women. One is in section 14. We all know under the circumstances under which the property which falls to a woman, whether before or after the enactment, becomes her absolute property, except under certain exceptions, that is when it is coming under a decree or an award or any such thing, a will which limits her right. Otherwise, all property which came to women initially only for her maintenance became her absolute property. So section 14 is a very important right insofar as the empowerment of women is concerned vis-a-vis whatever property falls to her share. And property is defined to mean all kinds of property, both movable and immovable, not just property which comes to her only in lieu of maintenance. In this regard, we all know about the famous case of V. Tulsamma Reddy versus Shesha Reddy on section 14, which has been interpreted by this court in 1977, 3 SEC 99. Then the other aspect is with regard to section 6. Now section 6 in 1956, as it stood prior to the amendment of 9 September 2005, it made a departure in the classical Hindu law. It introduced what is called the doctrine or the principle of notional partition, and secondly, daughters were given certain rights for the first time in joint family or ancestral property. Not just the daughters, any male heir belonging to the Mitakshara school who died intestate, leaving behind any female heir in class 1 of the schedule, was entitled to a share on the basis or on the device of notional partition. This happened in 1956. Now what would happen after that enforcement of the Hindu Succession Act in, I think it was on 17 June 1956, if any male heir having a property, a right in the joint family or ancestral property died, then his widow, his daughters of sons as enumerated in class 1, they could get a share in the share of the deceased Vitakshara male, and as a result, what happened? Till the enforcement of the 1956 Act, when property was going on the principle of survivorship only to the male heirs, ceased, and if there was a male heir who died after 1956, following the Mitakshara school, leaving behind a female heir in class 1, then the property would not be inherited on the basis of survivorship, but on the basis of the principle of notional partition. So therefore, if prior to 1956, if the father leaving behind 3 sons and 2 daughters died, the 2 daughters did not get anything. The 3 sons would succeed the entire co-pastory property or the joint family property. But after 1956, what would happen? The device of notional partition would apply as if the partition had taken place 1 day prior to the death of the father. Now the father and 3 sons are there. It would be divided 1/4 each. Then the father's share of 1/4, if he had not made any testament or will, that would again be divided amongst the class 1 heirs, which would include not only the female heirs but also the male heirs. So that 1/4 share of the father will again be divided amongst the 3 sons and 2 daughters, 1/5 share each. The sons will get therefore 1/4 plus 1/3, 1/5, but the daughters would get only 1/5 share. And if a widow was there, she would get also a share equivalent to what the daughters would get. Except in Bombay school, where the daughter would get, where the widow would get a share equal to that of the son. That is recognized by the judgment of this court in Gurpat versus Hirabai. I will come to that later. So this device, or by a fiction of notional partition, enabled women, namely widows or daughters of a male co-partner, to have a share in his share if he died intestate and not otherwise. If he had made a testament, then it would go only to the legatees under the will. So this is the new departure which was made after the enforcement of the 1956 Act, to give a small share to women, Hindu women, in the co-pastory or the joint family property. As I said, Gurupat versus Hirabai, that is AR 1978 SC 1239, in a beautifully written judgment by none other than Chief Justice Chandrachud, has explained what this notional partition is. And he says, we must assume that a partition has taken place 1 day prior to the death of the male co-partner. And once that assumption is made, that fiction or that assumption must be given effect to, and there must be an ascertainment of shares of the deceased co-partner, and thereafter, as per the section 6 read with schedule of the containing the class 1 heirs, the property must be divided. Now, after 50 years of this position, that is from 1956 till about 2005, the class 1 heirs who are female heirs getting a small portion of share in the father's share, the amendment came on 9th of September 2005. But in some of the states, particularly in Kerala, Tamil Nadu, Andhra Pradesh, Karnataka and Maharashtra, there were various enactments which were made prior to the central enactment of 9 September 2005. There they brought about something like a section 6 as amended in those states. But there again they brought about a restriction making a distinction between married women and unmarried, married daughters and unmarried daughters. So they said if the daughter was married, then she wouldn't get a share in the co-pastory or ancestral property, but if she was not married, then she would get a share. So that again was a subject matter of lot of litigation, and questions arose whether she should have been born before that enactment or after that enactment or after 1956. enactment or before that, because you know this personal law, this aspect, succession is in list 3 of the concurrent list, and therefore both the parliament and the state legislatures can make law, and there were many such questions which were pending consideration. But that is the reason why the parliament thought that let us have a uniform law throughout the country insofar as empowering daughters to have a share equal to that of the son insofar as co-pastory or mitakshara co-pastory property or joint family property or ancestral property, whatever you may call it. And therefore we have this amendment coming out after 50 years, where under section 6(1) there is a declaration made that a daughter is now a co-partner. See, under the classical Hindu law that is not so, but this is an engrafting on the classical Hindu law by a statute. Therefore we have to respect this, however much the brothers or the fathers or the males may not like it. But this is one way of empowering the daughters to have a share equal to that of the son in mitakshara co-pastory property. So what happens after that? There are two aspects. On or from the commencement of Hindu Succession Amendment Act 2005, that is with effect from September 9, 2005, in a joint family governed by mitakshara law, a daughter of a co-partner by birth becomes a co-partner in her own right in the same manner as a son. She has the same rights in the co-pastory property as she would have had if she had been a son, and is subject to the same liabilities and disabilities to the co-pastory property as that of a son. And any reference to Hindu co-partner shall be deemed to include a reference to the daughter of a co-partner. Now, while all effort has been made to give a greater share to a daughter, one cannot but realize that as a result of this, the share of the widow goes down. Because now, as I gave in that example, the father with 2 sons and the father with 3 sons and 2 daughters, now each one will get 1/5 share, and it is in that 1/5 share, you see, father, if you say, then it becomes 1/6 share. Then in that 1/6 share of the father, in that small share, a widow will get a share equivalent to all these. She gets 1/5 out of 1/6. 1/30th the widow will get, but a daughter will get now 1/5 plus 1/30. So this is one way of empowerment of daughter, but it is causing some concern for widows. Therefore it becomes a duty of the society now, on account of empowering daughters this way, to see that the mother, that is the widow, is also looked after. And I suppose that enactment of senior citizen now come in handy for such persons. Now, after the coming into force of this act, what has happened? The incidence of co-pastory property has now been widened, not just to the male co-pastors, but also to the female co-pastors. As a result of this enactment, several questions arose. Naturally, there were again a lot of unrest in the society, and the questions were whether the amendment will apply to daughters born prior to the date of enforcement of the Hindu Succession Act, that is 17 June 1956, or to daughters born after the Succession Act, or to daughters born only after 9th September 2005. Then the next question was whether the amendment is to be applied retrospectively or prospectively. Then again, question is whether the father and the daughter should be both living on 9th of September 2005. These questions arose in several courts. I am sure there were a lot of Order 7, Rule 11 CPC applications filed by the brothers and the fathers to see that the plaint is rejected under Order 7, Rule 11, when the suits were filed by the daughters. I am told that even daughters who were in their 90s started filing suits. And there was a flood of litigation and the trial courts saying, give me a share. Of course, what was saved is whatever transaction had taken place prior to, I think, December, that is December of 2004, the day when the bill was introduced in the parliament, they were saved. Provided there was a registered partition deed and there was an oral partition which was acted upon. That means there were mutations made, there was division by metes and bounds and separation of the joint family property as such. Then all these questions were culminated initially in what is known as Prakash versus Pulvati decision. That is a case which arose from Dharwad, Karnataka, and the apex court, this court, analyzed the unamended section 6 and the amended section 6, and they came to the conclusion that insofar as substantive law is concerned, when an amendment takes place, it is always prospective. But if there is a procedural law, it would have been retrospective. Therefore, I think Justice Goel's judgment, he said that the rights under the amendment are applicable to living daughters of living co-partners as on 9th September 2005, irrespective when such daughters are born. So therefore, some cloud was removed. They may be born prior to 1956, subsequent to 1956, or even after the amendment. It doesn't make a difference because they get a right by birth. Just as the son gets a right by birth, the daughter also gets a right by birth. What used to happen prior to this, the position was the right of the daughter was recognized only on death of a male co-partner. But now the sea change that has come up is that she gets a share in the joint family property or ancestral property on her birth. So there cannot be, or there must be as rejoicing when a daughter is born as a son is born. Because earlier there used to be a lot of rejoicing only when a son used to be born, forgetting the fact that he would take away a share. But now it must be a rejoice for both daughters and sons, because there is now a level playing field. All of them get a share on their birth. But you know the difficulties which arose out of the judgment of Prakash versus Pulvati, merely because there was a date, 9th September 2005. Many daughters lost out because the father was dead or the daughter had died. Therefore, her children lost out. Therefore, again, there was conflict of opinion amongst the legal experts and in court's decisions. This is highlighted in two judgments of this court. One is Danamma versus Amar, which is also a case from Karnataka, where the question was whether a daughter could be denied a share in her father's property on two grounds. Firstly, because the daughter was born prior to the enactment of the Hindu Succession Act 1956, and secondly, because her father was not alive on 9 September 2005 when the amendment was brought about. Now in Danamma's case, this court applied Pulvati, the doctrine or the principle in Prakash versus Pulvati, very selectively, and it did not apply with regard to the other aspects of the case, because there is another underlying principle in all this, which is on what date succession opens. Till now, the date on which succession opened was the day of death, and the principle of notional partition was pressed into service, saying that there would be a partition, notional partition, one day prior to the death of the male Hindu. Now, that aspect could no longer hold true, and therefore, in Danamma's case, this court neither applied the Karnataka amendment, because by then that was repealed. Not repealed because of Article 224, it was no longer applicable. It could not be on the statute book, it was repugnant, and neither was Prakash versus Pulvati applied. Then we had the next case of this court, the judgment in Mangammal versus T.B. Raju, which is a case which arose from Tamil Nadu, where a married daughter filed a case in 2003. And in Mangammal, what they said, they made a departure from Danamma and Pulvati, and they said, they made a departure from Dhanamma and applied Pulvati, and they said that since the father was not alive on 9th of September 2005, in that case the daughter was not entitled to it. So therefore what happened? The law went back to what was prior to Danamma, that is Prakash versus Pulvati. Now we have on the one hand a conflict of decisions in Danamma, and on the other hand the same conflict as against Mangammal and Pulvati, and as you all know, the matter was referred to a larger bench in Vinita Sharma versus Rakesh Sharma. Now what did this larger bench say in Vinita Sharma? Very important. They said that on and from 9/9/2005, though the rights may be claimed from that date, the provisions are retroactive in application. They confer benefits based on the antecedent event, and the Mitakshara co-pastory law shall be deemed to include a reference to a daughter as a co-partner. So this is by retroactive what you call device, that they said the daughter is entitled to co-pastory rights from the date of her birth. That it is not necessary that the father should be living as on 9th of September 2005 so as to enable a daughter to have a share in the co-pastory property, and this court discarded what is called the living co-partner concept, which was there in Pulvati's case. So what happens as a result? Daughters are entitled to co-pastory property irrespective of their date of birth and irrespective of when their father died. And the concluding observations of the Supreme Court in Vinita Sharma are very important, apart from the fact that the co-pastory property is by birth and the father need not be living as on 9th September 2005. This court said that the substituted section 6 will apply even if there is a preliminary decree passed by any court, and in pending cases it will apply so long as no final decree has been passed. See, this is again great departure in order to ensure that the statutory amendment is given effect to. Earlier, what was the classical law? Once a male co-partner signaled or made his intention clear to the rest of the family that he would like to sever, that would be a partition. The joint status would become what is called from joint tenancy to tenants in common, and thereafterwards it was only a matter of division by metes and bounds. So the status of jointness came to an end. There was a severance of status, or they say a division in the family, once one of the co-pastors wanted to separate. But Supreme Court said now no longer that classical principle will apply, even if there is a preliminary decree, because we have another principle that once a suit for partition is filed, that is an intention to divide. It is a division of status, severance. But now, is it too loud?
No.
I'll wind up.
Mic. It's going.
Tell me if I'm crossing
please.
the
No, it's a
time.
high peak. It's
I hope I'm not.
all over India is suffering, so that's very important, man.
Yes.
Now this court has given three judgment that is very.
Sorry.
No, it's amazing.
Yes. So therefore, the severance of status which would apply the moment an intention was made by a male co-partner, that also goes, because the now the amendment will apply even to pending proceedings, even when a preliminary decree has been drawn, so long as no final decree has been drawn. Even if the final decree proceedings are going on subsequent to a preliminary decree, this amendment must be applied. This is on the principle that even after a preliminary decree is drawn by a court, when there are births, the shares go down. and when there are deaths, the shares go up. So on applying that principle, this court said that the statutory amendment must be applicable even to final decree proceedings. And if there have been any oral partitions, that will not be applied until there is concrete proof that the oral partition has been acted upon, there is severance in status by metes and bounds, by separation on the basis of mutation, etc. And they must, by an oral evidence saying there was a prior partition, will not be accepted. So there are several takeaways now after the judgment of Vinita Sharma. If you carefully read the judgment, according to me, I have made about 6 different types of what you call salient takeaways from the judgment. I need not read it again to this enlightened audience, but only say that if you read the judgment, both you see between the lines and the lines, you will get to know what are the departures that have been made by the Parliament, and as to how this court has given intention of the Parliament and enforcement, because all the clouds are being wiped out, grey areas are being removed. Then in Vinita Sharma's case, there was another departure made from Uttam versus Saubhag Singh. See, the question is, when this notional partition or division takes place, it is only with regard to ascertaining the share of the deceased male co-partner. The rest of the family continues to remain joint. But in Uttam, I think this court came to the conclusion that when once a notional partition takes place, everybody's share has to be ascertained and everybody becomes separate. The joint family comes to an end. With great respect, that is not the position. All of us are knowing we are continuing in joint families, at least on paper, from insofar as properties are concerned, even if our relationships may not be so good with each other, because the joint family is an eternal concept of India, and that continues. It doesn't come to an end with the death of one of the Mitakshara and the share of that deceased Mitakshara male being ascertained. Then subsequent judgments I tried to find out. Arunachala Gounder versus Ponnuswamy, 2022 Live Law SC 71, and another one is with regard to the Geetabai Maruti Rawat versus Pandurang Maruti Rawat, AR 2022 SC 388. They have again reiterated whatever has been said in the Vinita Sharma's case. Now, with regard to the past transactions, I said the Parliament has protected it, and that has been affirmed by this court, saying that all past transactions prior to December, I think 2004, they cannot be reopened or revisited by means of asking for reopening of partitions which had already taken place. Now, in this context, what I said is, with regard to the preliminary decrees and the final decrees, whatever is the time frame, final decree proceedings, pending proceedings, there also the amendment applies. In that regard, what is important is Ganduri Koteshwaramma versus Chakkiri Ennadi and Sai Reddy versus Narayan Reddy. These are the 2 cases of this court where which have been taken care of so as to ensure that the amendment applies to the existing cases also. Now, when we come to this what we call the rights of Hindu women, I would like to depart a bit and say that when it comes to tribal women, see, they are not considered to be Hindu women as such. Therefore, I was trying to find out what are the rights of tribal women, because I was asked to speak at, of all places, in Ranchi in Jharkhand, where the tribal population is to a large extent, and I was reading the property rights of tribal women, their local laws. But you see, in Hindu Succession Act itself, subsection 2 of section 2 says notwithstanding anything contained in subsection 1, nothing contained in this act shall apply to the members of any scheduled tribe within the meaning of clause 25 of article 366 of the constitution, unless the central government by notification in the official gazette otherwise directs. So the 1956 act itself has been very, very wisely taken care of the situation that the rights of tribals with regard to the property insofar as application of Hindu Succession Act is concerned is on a very slow pace. Unless the central government notifies, this Hindu Succession Act cannot be actually applied to the tribal population as such. Now I know all of you have had a long day and it is a Friday. Many of you must be excited to communicate interim orders or successes that you have had, or anyway communicate whatever happened. So I will not stretch it too long because I came late to this evening session. But I would only conclude by saying that no doubt the law has been marching from time to time so as to empower women insofar as property rights are concerned. Now what has happened? Women are again vulnerable because they personally may not be interested to seek any share in their father's property, but many a times they are forced to seek such a share, probably from the husband's side. That is why I said they are not only unsatisfied with the dowry that is brought, but they also says get property now. Section 6 has been amended, and therefore due to those pressures many women file the cases. Now please don't mistake what I am saying. What I would say is we have to ultimately bring about what you call peace in the society, where I find no doubt these rights are very important for women, particularly when a woman is suffering, where she is thrown out of the husband's house, or the husband's family is not well off economically. She is in need of all these, as a share. In such cases, a woman definitely, a married woman, can ask for a share in her father's property, that is Mitakshara property. But I find very sad when, very well-off women, they need not exercise this right, because ultimately, to file a suit against your parents' family, that I feel is a little sad. It may be my personal opinion, but kindly excuse me. If such kind of matters come up, then I feel that they should settle. Firstly, they should not engage in such kind of legal proceeding, because many a time the father and the brothers are not so well off as the daughters are. We have come across such cases during the course of first appeals which have come up. I am sure Mr. Justice Basant has also come about, or these cases. So I am not saying don't exercise your rights, but be very, very sensitive while exercising your rights. Ultimately, a woman would like to have peace both in her husband's family and in her father's family. It is only a woman who has two families. Otherwise, technically, the male has only one family. But the woman has two families, so she has to balance. If a woman really is in need of it, yes, please exercise your rights, enforce them. But if she is well off, she is what we call the creamy layer. She does not really require this property. She has earned on her own. She has otherwise vast assets in her husband's house. Then I think she must allow her parents and her brothers to enjoy that share also. It all ultimately depends on her sensitivity. The converse also, I would say, that the brothers and the fathers must invite the daughters, whether they are married or not married. If a partition is to take place, to say, come, daughter, this is your share. It cannot be done behind their back. And that will lead to again heartburn, because when the law gives this tremendous, right to a Hindu woman to say you are as worthy as a son and no less. You are a co-partner by birth. If some arrangement or partition takes place between the father and the sons behind her back, she would feel hurt. Therefore, let the sons and the father or uncles, where there is joint family, invite the daughters and they say, look, we have this difficulty, we can't give you this much, but we are willing to give you this much. I am sure the daughters will happily have a give and take. There must ultimately be, what I am trying to say is, empowerment should not result in unrest. Empowerment should not result in breakup in society. Empowerment should not result in severance of relationships in the family. Therefore, there is a give and take that has to be taken or made on both sides, and therefore I urge all co-partners, male or female, to have that sensitivity insofar as their rights to property is concerned. Of course, those who have no property have no difficulty at all. Their relationships continue. But that does not mean the converse, that if there is property, the relationship should not continue, or there should be unrest, or there should be no fraternity in the family. Ultimately, we should all live together because Indian society depends upon family. That is our strength. Unlike the West, where families are breaking up, where it is in India, what is unique in India is our family system. And we have families, we have extended families, and the whole nation is a family. Therefore, let us see that the smallest unit of society is not broken up because of empowerment. Now, with this short or long talk, as you may call it, I thank Mrs.Justice Rao, the administrator, for giving me this opportunity to speak to you, and to each one of you for giving your attention on a Friday evening. Thank you.
Let us give, all of us, let us give standing ovation to our ladyship. Yeah, please. Thank you very much, ladyships.
Yes.
The way you balanced everything, the society.
Yes.
Wonderful, very rare, exceptional lecture we heard. I think one of the best lecture we have sitting judge of this court. And Archana Sahadeva will give a vote of thanks. Very short, please, you cover that side.
Thank you, sir.
Yes, sir.
Honorable Justice Nagarathna, respected seniors, and dearest colleagues and friends. I am privileged and honored to be asked to deliver the vote of thanks to this august gathering on its 160th meeting. Justice Nagarathna has always been kind to the Friday group and never said no to any of our requests for participation in the Friday group activities, notwithstanding her busy schedule. We are eternally grateful to you, ma'am. The members of the Friday group and the bar have listened to your lecture with rapt attention, and thank you very much, madam, for the erudite and illuminating speech on the subject Hindu women's right to property, road to empowerment. Your discourse on various facets of women empowerment, need for an all-rounded empowerment and development of women, contribution of a homemaker to a country's GDP, teachings from Manusmriti, and finally, tracing the legislative history of development of women's rights to property in India, along with case laws, was particularly enthralling and educational. While I appreciate the fact that equal rights to property in women has made great strides, what intrigues me is this. Why has it taken 76 long years since the coming into force of the Constitution for the first women CJI to be sworn to the Supreme Court? Going by the proportion of female population to the total population of the country, women are entitled to 50% of the posts in the judiciary. Even going by the conservative standards and taking a cue from the Women's Reservation Bill, women are entitled to occupy at least 33% of the posts. As per 2021 data of the Law Ministry, 18% of the posts of the judges in district courts are represented by women. Of course, the figures vary from state to state. To leapfrog from 18% to 33% is not an unachievable task. The formidable problem, however, is the meager, less than 12% posts occupied by women judges in the high courts. Justice Nagarathna, ma'am, your task is cut out with time on your side and the unanimous strength of the bar behind you. We hope and pray that you find the strength to achieve this humongous task, and our best wishes to you, ma'am. Thank you once again, ma'am, for engaging with our group and encouraging us. Thank you.
Friends, just wait for another program 5-10 minutes. Now we completed 75 years of our India's freedom movement, independence. So for that, our Friday group I circulated August 7th, those fought for Indian freedom movement, freedom struggle, lawyers role Indian freedom movement. Several entries are entered. I have received 19 articles. So senior advocates also, Mr. Subodh Markandeya sir is here, Justice Karpaga Vinayagam is here. Thank you very much, sir. Persons of your page, even though a lot of this thing and other this thing. Now, those who stood first, Madam is going to give that Constitution of India calligraphic translation immediately. But one thing interestingly, all senior advocates they given up to encourage junior advocates. Even though they selected, particularly Subodh Markandeya stood first. He said, I don't want, let us encourage juniors. So I am very grateful. Now who is that junior? Let us wait. I will discuss. I think who is J here? Any J sim name is here? I think somewhere here Jyoti Parashar. Yes. Women empowerment looks like it's not my choice. Person is here. He said, don't disclose my name. He took promise from me. So I am not disclosing that who examiner and corrected papers and all. First they given first mark to Sir Markandeya sir and equally to Ajit Kumar Sinha, but he missed 15 advocates' name. One you have to mention full article, 500 words, 1000 words, minimum 15 names of the not only Gandhi, Nehru and Sardar Vallabhbhai Patel and other parts of the country, even southern part, northeastern part, several advocates they given their life and fought for this thing. So very good response honestly. So I circulated in the today how many people, one name I missed, that I'll add it something. Now we'll start it. This is I purchased from the Parliament House. Please clap. Please come Jyoti. Take photograph. Take photos. So rest of the people also, all participants will get some certificate. Madam recommended for certificate. Let us see. All will get in a short term or next any program. All participants. Yeah, please. Take it on table and.